Next, I'm pleased to introduce our next speaker, Justice Charles Daniels. Justice Daniels has been on the New Mexico Supreme Court since 2007. Before joining the court, Justice Daniels was an attorney for 38 years, practicing a range of criminal and civil law and accruing many awards. Justice Daniels is a graduate of UNM School of Law and was a former editor-in-chief. Please join me in welcoming Justice Daniels to the stage.
Thank you. I'm not sure that I was invited because I used to be an editor of your magazine, or if it's because I was on the court that decided the case that some people in the room are unhappy about. In fact, I had someone come up when I arrived about 30, 40 minutes ago saying, "I hope you'll learn the error of your ways after you hear everything." Let me just say at the outset, I wasn't asked to speak so much on the assisted suicide or aid in dying case. I was asked specifically to talk about the history of state constitutional rights in New Mexico, and I'll get to that in a moment. But I want to emphasize the role that I have to perform as a justice of the New Mexico Supreme Court, and it is to try as best I can to honor my oath to support and uphold and apply the Constitution of New Mexico, the Constitution of the United States, and the laws that are enacted by the representatives of our people in a representative democracy. There are cases I end up voting on, writing on, issuing along with other members of the court that reflect my view of how I should perform that role, and that may be inconsistent with what I personally would prefer to be the bottom line result in terms of practical results. As I was listening to Dean Chemerinsky, who's an eminent scholar with whom I have the greatest respect for, talking about his father, who died 24 years ago in Indiana, it brought back memories to me of my mother. I was very close to my parents. I was fortunate to have had two wonderful people as parents. She died about a year after Dean Chemerinsky's father in Arkansas had a debilitating stroke. It destroyed any possibility of any meaningful life. Left her unable to care for herself, left her in misery. And I sat and held her hand as she died slowly and heartbreakingly. My views on assisted suicide, physician-assisted death, are irrelevant to what I have to decide in applying the law. And so I'm not going to talk about what my views might have been, but anybody who's gone through that experience probably wishes they had a way that they could treat their humans as well as they treat their dogs. Coincidentally, I have a dog dying today, and my wife is at home tending to the dog. The dog might not make it till I get home, but at least my wife has the option of taking it to the vet and putting it out of its misery if it gets in great pain. But I'm here to talk about the role of independent state constitutional rights in New Mexico. New Mexico actually has had a vigorous application of its state constitution, particularly in the last 30 years or so. There was a time when that was not so. Right after the Warren Court era was over in the 70s, when the court changed from what's considered politically liberal to politically conservative, around the time of the Nixon administration, we had a relatively conservative New Mexico Supreme Court. And I recall an opinion that court issued where the court in New Mexico, in very clear, almost angry terms, said, "We will not interpret our state constitution a single millimeter more liberally than the requirements of the United States Constitution." Basically, the New Mexico Supreme Court of that time had what is called the dependent or lockstep approach to interpreting the state constitution. That is, whatever the U.S. Supreme Court said that the U.S. Constitution required, well, that's what the words in our state constitution meant, and whenever they changed their view of what the federal constitution required, then we would change our view of what the state constitution required, essentially rendering the state constitution a meaningless clone of the federal constitution and having no independent significance. Those days are over. Beginning in the late 1980s, the New Mexico Supreme Court departed from the lockstep approach. It was at a time when the U.S. Supreme Court was departing from its own precedents that we'd followed in applying the law in New Mexico, both in applying the U.S. Constitution, which we have to do because they're the final voice on that, and even though we can decide what the U.S. Constitution requires, they grade our papers and will reverse. Justice Scalia has reversed me once already. He can't do it anymore, but that court can do it, and under our system of government, that's their right. It may not be that they're wiser, it may be that they are, but that's irrelevant. That is their role, that is their function. They have the right to have the final say on that. They don't have the right to have the final say on what our state constitution means. That is assigned to the court that I am fortunate to be a part of and have been for the last 10 years. It is not only our right, it is our responsibility to interpret the state constitution and to give it meaning, not to make up the meaning we prefer it have, but to try to give it the meaning that it's intended to have. I've been reading de Tocqueville's Democracy in America again recently. Most of you probably are familiar with that two-volume set. De Tocqueville came to the United States in the early 1800s, around 1830, and was an educated Frenchman who was an outside observer to this new experiment that was going on this continent, this experiment in self-government, this experiment in checks and balances and divided powers of government. He quoted James Madison in The Federalist, the publications that were issued by Madison and Hamilton as the U.S. Constitution was being contemplated in this country. And let me get the pages from Democracy in America. And he talked about Madison's observation that in this new system of government in the United States of America, the judiciary was the least dangerous branch. That the other two branches, the political branches, the executive and the legislative, were at risk of swaying to popular passions and prejudices of the time and sometimes denying individual liberties and rights. And that the framers of the Constitution did something very important. They recognized that human beings tend to act in their own self-interest. That's one of the reasons we have so many checks and balances in our government. And that people perceive their self-interests in different ways. And this is not quite the way de Tocqueville articulated it, but I think this is what he meant. That at the moment, we sometimes act in our self-interests that may cause us to do things that are really not in our long-term self-interest. And when we set up this government, I say we collectively, the people of the United States of America, we acted in our long-term self-interest in providing the basic structure of government. The people thought, you know, there'll be times when I don't want to hear speech. I don't want to read writings of people that I think irresponsible or stupid or dangerous or antisocial or whatever. And sometimes our people act on those kinds of feelings in the short term. But they recognize that in the long term, it is in everyone's self-interest to have freedom of speech for everybody, no matter what the content is. To have equal protection of the law, even though there may be times when we want to ban certain religions or certain philosophies or certain political interests and so on. And so when the Constitution was created, it was really created in the long-term self-interest of the people of this self-government that was being created on this continent. The guarantees that are written in the Constitution are a limit on the power of the people in their representative form of government to enact certain laws. The people were taking away power for themselves in the future to keep them from acting against their long-term self-interest, recognizing they may be inclined to act in their short-term self-interest with the passions of the day. And those are basically the kind of guarantees that are written into the Constitution, into our Bill of Rights, in the federal Constitution, and in the state Constitution, various other structures. Those are parts of the law that are in our long-term self-interest, that the people don't have the right to have their representatives in the legislature and in the executive branch overturn on a case-by-case basis. If they want to change those fundamental laws, they have to go through the process of changing the document that was written in their long-term self-interest. And that is a very serious step and not one that has ever been taken lightly. And I think there was a lot of wisdom in doing that. The judicial branch was assigned the responsibility of making sure that we remain true to the basic charter of our government, the contract between the people and the government they founded, and to make sure that on the short term, we didn't violate those basic guarantees. It's somewhat of a limitation on the power of the people. There's still a lot left, and ultimately, most changes in the laws need to take place in the legislature with the approval of the executive, expressing the will of the people from time to time, so long as they don't transgress those fundamental norms. De Tocqueville said that armed with the right to declare laws unconstitutional, the American judge cannot compel the people to make laws, but he can at least insist that they not break faith with the laws they have made and remain consistent with themselves. He can insist that they not violate the basic charter of their government. And he said that confined within proper limits, the power granted to American courts to pronounce on the unconstitutionality of laws still constitutes one of the most powerful barriers ever erected against the tyranny of political assemblies. Confined within proper limits. What he's talking about is that we should not become a tyranny in ourselves in the judicial branch and confuse our role with that of the democratic people and the people they elect. Elections have consequences. I don't know about the rest of you. I suspect it's true of you as it is of me. Sometimes I'm disappointed in election results. I'm not talking about any particular election, but sometimes I think, what could those other people be thinking? But ultimately, it's not my decision to say, well, I don't like the results of that. I'm going to throw that office holder out or decide that their laws don't have any meaning. We have to apply legal norms in evaluating them. Well, New Mexico, the New Mexico Supreme Court started its venture into application of its state constitutional rights as the Burger Court departed further and further from the holdings of the Warren Court. And in part, it was not so much creating new constitutional rights in New Mexico, it was just saying, you're not taking away the ones we already have. This is what our Constitution meant before. You can decide in Washington, the Potomac 9, as opposed to the New Mexico High Five. You can change your interpretation of what the United States Constitution requires, but that doesn't automatically mean the words change on the paper here in the New Mexico Constitution. The first real step was in 1989 in a case called State versus Cordova. And it was one of a series of search and seizure cases as the United States Supreme Court began limiting more and more the right to be free from unreasonable searches and seizures and expanded police power to intrude on citizen privacy and conduct searches without warrants and other such things. The New Mexico Supreme Court started saying, whoa, our Constitution is not going with you. And so in 1989, they decided to case State versus Cordova. I say they, I guess institutionally it's we, but I wasn't on the court then, and I can't take any credit for Cordova. I didn't come on until 2007. But the U.S. Supreme Court had departed from an earlier precedent under the Fourth Amendment that we'd been applying both under the Fourth Amendment and under Article 2, Section 10 of the New Mexico Constitution, which has an identically worded guarantee against unreasonable searches and seizures. In the earlier U.S. precedent, there were a couple of cases, Aguilar and Spinelli, Aguilar versus Texas and Spinelli versus United States, where the U.S. Supreme Court said that as a matter of federal constitutional law, when you're interpreting the sufficiency of an arrest warrant or a search warrant, and it's being based on hearsay, there has to be some information given to the judge who has to make the decision whether to issue the warrant as to who's this person that's not coming before me that's giving you this information? Why should we believe this person? Tell me something about it to let me know why we think he's a person to be believed, and how did he come by the information? It's called a two-pronged test. That was a matter of federal constitutional law. Well, the U.S. Supreme Court said, they had decided a case called Gates in the 1980s, and they said, well, you don't need all those technicalities anymore. It's just sort of, it feels like it's enough. You don't have to show independently the credibility of the informant or the way by which the informant came by the information that's being passed on through a third person here to a judge to issue a warrant. And so a similar case came before the New Mexico Supreme Court in 1989, and it was the first one where the New Mexico Supreme Court said the federal constitution is drifting away, but we're holding on to our state constitution, and held that that same two-pronged test that had been federal constitutional law interpreting the unreasonable search and seizure clause it would be continued to be applied under the New Mexico Constitution, and we've applied that ever since. That was the first example. There was no analytical theory that was identified. There are half a dozen different theories for distinguishing between state constitutions and federal constitutions. It's sometimes important to try to come up with some kind of theory or concept or set of principles to analyze these kinds of cases, particularly where you have language that's virtually identical or maybe have been historically interpreted in the same way. It was a few years later that our court finally articulated a theory. There were a couple of more cases that happened. 4 years later, there was a case called Gutierrez, also a search and seizure case, where the United States Supreme Court had taken the federal constitution off further from the limitations that it had recognized under the Fourth Amendment right to be free from unreasonable searches and seizures. And they held, they created a good faith exception that some people call the close enough for government work exception. That even if a warrant is invalid, if a reasonable police officer could have been mistaken, and we won't look into what this officer thought, but even if the police obtained an invalid search warrant and talked a judge into issuing it, we're not going to exclude the results of the search unless no reasonable police officer could have thought this might be enough. That close enough for government work exception is still part of federal constitutional law. But our Supreme Court in 1993 in Gutierrez said, close enough for government work is not good enough for the Constitution. and held that if it's a valid warrant, the evidence comes in. If it's invalid, it doesn't come in, and it's just as simple as that. Otherwise, those guarantees in the Constitution are not as meaningful as they appear to be on their face. They say, maybe you have this right, maybe not. If a cop could be mistaken about what the Constitution requires, well, tough, you don't get this right. So in 1993, we decided that we would not follow the so-called good faith exception, and invalid warrants don't result in admissible evidence. In 1994, State versus Campos, our court decided that if you have time to get an arrest warrant before taking someone into custody and depriving them of their liberty, you ought to go to a judge and get an arrest warrant. The federal law is that if you have probable cause to believe someone committed a crime, a police officer can just go make an arrest without having a judicial officer interposed in the process. That's still the law under the New Mexico Constitution. In 1997, State versus Gomez articulated and adopted a theory, finally, for deviating from what the U.S. Supreme Court is doing with the federal Constitution. Deviating is probably the wrong term, choosing not to follow the direction the U.S. Supreme Court is going. And we adopted what's called the interstitial approach. And that is a several-step analysis. It requires where the constitutional protections seem similar on their face. For example, the Fourth Amendment, right to be free from unreasonable searches and seizures, a right to freedom of speech, those kinds of guarantees, due process and equal protection. They're textually indistinguishable. That first, the court, our court, will look at whether the right that's being claimed under the state constitution is protected under the U.S. Constitution. And we'll look to see whether the U.S. Constitution protects it, because if it protects it, it doesn't make any difference what the state constitution does. If it's a federal constitutional right, that overrides anyway. And there's no need to reach the New Mexico constitutional claim if something is protected by the U.S. Constitution. But it's when the U.S. Constitution is deemed not to protect the right of the citizen that we look to see whether the New Mexico Constitution independently does. And under that, we have to determine a number of factors. Is there a flawed federal analysis? Do we find something illogical or unsound about the federal analysis in interpreting this language? Are there structural differences between the state and federal government, or are there distinctive state characteristics that call for reading our constitutional provision differently? And under the interstitial approach, the party trying to apply the state constitution has to provide reasons, both at the trial level and on appeal, for interpreting the state constitution differently from the counterpart federal constitution. And that approach has essentially been used for the 20 years since Gomez was decided in 1997. It's been applied mostly in search and seizure cases and in criminal cases generally. There are a few cases that have applied it in arenas outside criminal law and procedure, but most of them have been search and seizure cases that deal with the reasonableness requirement of Article 2, Section 10 of our state constitution. There are probably about a dozen cases where we've departed from the federal court's direction. One of the more significant ones is that we decided a case right after I came on the Supreme Court that held that citizens have a reasonable expectation of privacy. That is, they have protections against unwarranted searches and seizures of what you put in those plastic trash bags and put out on your private dumpster and roll out to the street. The federal U.S. Supreme Court has said, well, when you put your trash out there, you don't have any privacy interest in it anymore. You don't care if people look in there. You've abandoned it. I don't know how those justices feel. I put the most intimate things in my life in my trash bags that I don't want anymore. I mean, it contains everything that's been in my dresser drawers, in my bathroom, my kitchen, my papers, my tax returns, all the secret stuff that we try to keep private. Back in the days when I did love letters, other than the birthday cards to my wife, some of those would end up in there. And I think most people are probably like me, and that's what we had to try to decide on this. What reasonable expectation do people have generally? That when we put that out there, we're not saying, hey, everybody, we want you to come look at this and see what I've been putting in my body and doing in my personal life. We put it out there to be destroyed and to be disposed of, because we don't all have incinerators in our homes. And in that case, our court said, if you have reason, officers, to search in somebody's trash bags out there in the collection container that is identifiably this person's in this home, we go to a judge and get a warrant and show what your cause is for going there and going through their diapers and their hygiene products and all those kinds of things, dental floss, whatever else ends up in there. And so we decided that under the state constitution that is what we believe people in New Mexico considered private, and that it would be an invasion of privacy to allow police to be rummaged around without cause and without any kind of justification from a neutral judicial officer. There are a number of other cases in the search and seizure area. I don't have enough time to go through them all. I'll be glad to provide citations and all that if anybody's particularly interested. There are a few cases outside the criminal arena where we've applied the independent state constitutional analysis. One of them was in the marriage cases that we had before the United States Supreme Court had the Obergefell case. Griego versus Oliver was the case that came before our court. And I'll caution that we decided that case not based on our own preferences, whatever they might have been, just as in the aid and dying cases, I don't recall asking the other justices, hey, what are your personal beliefs on this? We talked legal principles and wrote them up as the opinion of the court and the official opinion of the court. But we had before us cases where the state was attaching various kinds of benefits and detriments to certain relationships. And by defining marriage in a certain way and as being limited to people of opposite gender couples, and tying that to various benefits that the state provided, tax benefits, inheritance benefits, all kinds of things that were granted to some citizens and denied to others based on the gender of the person they had committed relationships with. It was a case that we decided on our equal protection clause. This violated equal protection of the laws. And we decided under our state constitution, it wasn't clear what the United States Supreme Court was going to do. There was a lot of speculation about it, and the views up there, as Dean Chemerinsky had noted, had evolved with regard to the justices on the U.S. Supreme Court and their views of the United States Constitution. But that was a unanimous opinion out of our court, and we decided that based on what we thought the Equal Protection Clause of our state constitution required. They don't treat people differently unless there's some kind of a good justification for treating them differently. And the state couldn't come up with any good justification for defining all these property benefits and detriments, government benefits, based on the gender of the person that they were in a committed relationship with. So Griego was one where we applied that. It was just a year before the U.S. Supreme Court changed its position in the Obergefell case in a 5-4 split decision, which is fairly common on that court, which has become more politically polarized. I'm not making a value judgment, I'm just being descriptive. The justices are selected there by people of all political persuasions, whether they're liberals or conservatives in the political branches. The justices of the U.S. Supreme Court are picked for ideological as well as competence reasons. we decided two cases the same day in 2016. One of them was the aid and dying case, and the other was Rodriguez versus Brand West Dairy. And we had different people taking comfort and chastising us for our decisions in those two cases. The politically conservative people liked our decision in the aid and dying case and hated our decision in the workers' comp case. The workers' comp case, you may not be as familiar with that as the issues you're dealing with today, but it was a case where the New Mexico legislature had enacted an exemption from the workers' comp statute. That's the statute that allows compensation for people whose bodies have been hurt in the process of carrying on the business of their employers. Basically, their bodies being used up in the process, and under the workers' comp statutes, the employers, like they have to fix a vehicle, they have to pay to provide some compensation to the people whose bodies have been used up in the process. But they had an exemption in the statute. And it wasn't for agricultural workers in general. It was for farm and ranch laborers. Someone working in the front office in a farm or ranch got workers' comp. Someone who was a manager got workers' comp. Someone who did the packing and the shipping got workers' comp. But if you're out there sweating in the chili fields, you got hurt, tough luck, you didn't get workers' comp. And that was brought to us under the Equal Protection Clause. And we couldn't find a rational distinction for separating out the laborers from the other workers in the same industry. There were arguments that we needed to keep the costs of agricultural products low. We needed to protect New Mexico farms and ranches and dairies against competition from south of the border and from other states and keep the cost of the product down. But that argument would have applied if there had been an exemption to anybody working in the agricultural industries, but this wasn't that. It was the laborers, the ones who were sweating the hardest, were the only ones who got denied, and not the other people whose workers' comp costs contributed to the cost of the ultimate product. And we couldn't find a rational distinction for saying that to protect the cost of the product, you can say, as to this class of workers, you don't get workers' comp, and as to the others, they do. And so we struck down that as violative of the Equal Protection Clause. Ultimately, regardless of whatever our personal views might have been on aid and dying, and again, I never asked my fellow justices about this. I suspect several of them had gone through the same kind of experience that I'd gone through in my life. We had to recognize the difference between our roles as judges and our preferences as human beings, as citizens, as voters, as to what we would like to see done in the lawmaking branches of government, and decide whether as a matter of constitutional law we saw in the Constitution and could articulate for future application a constitutional right in some definable manner. That dog of mine who's dying today, when it was moving around, had a habit of chasing cars. And I remember saying to my wife, I wonder if that dog would ever figure out what to do if ever caught one. And one of the things we have to think about on the court is not how we would like to decide this particular case for these particular people, because in a precedent-setting court like ours is required to be, where the opinions we write become part of the fabric of the law and become precedents that people have to follow, that judges have to apply, that litigants and lawyers have to be able to predict, and they can be applied in the future with some kind of definable, predictable legal standards, we have to figure out what would happen once we catch that. If we said in broad terms, there's a constitutional right to physician's aid in dying, then we have to take the next step. All right, how do we define that? What we're saying is that there's a sphere of lawmaking that the people are not allowed to engage in through their elected representatives once we take that out of the permissible range of legislation. Now, causing the death of another person is a subject of a lot of our statutes. There are actually a lot of people out there who'd be glad to help other people die. Rival gang members, ex-spouses, pending ex-spouses, all kinds of people who are willing to help other people die. And I know in this situation that's not that, but the legislature defines what classes of killing other human beings is going to be lawful and which is not. If we decide that there is a constitutional right to physician's assistance in dying and that the people through the legislature can't change that, then we have to say what they can't do. We looked at as we describe in the opinion, I'm not going to describe the inner workings, it would be improper. We speak only through our opinions as a 5-justice court, and I don't speak for the whole court. But in our opinion, I think we fairly well articulated. We looked at the Oregon statute. It's one of the 5 states or so that has a legislative aid in dying law. And it has various standards in there. A doctor has to certify that you're suffering from a terminal illness. A doctor has to certify that you only have 6 months to live. A doctor, a psychiatrist, or other qualified person has to certify that you've been consulted and that you're capable of making a rational decision, and that you, the patient, you are making a rational decision and a conscious choice, and it's not being imposed. There are various steps that are required in the Oregon statute. So we inevitably would have to ask ourselves, well, what part of that can the people do or can't they do? For example, if the New Mexico legislature was to enact a statute that says you have to have 3 doctors certify that all these conditions exist, would that be unconstitutional? If we say that only 1 or 2 doctors have to certify to it, then it's constitutionally required to be honored. What about if the person is suffering from horrible pain and is inevitably going to die and is never going to get out of that misery bed, but it's going to take a year or 2 years? Does that person have a constitutional right? Oregon, by the legislature, created policies that balanced all those kinds of things, picked the 6-month cutoff. If we create a constitutional right, we have to decide where that cutoff is going to be and where it can't be. We have to decide how many doctors have to certify and how many can't, and those kinds of things. So unlike the dog, we have to think about how we would articulate the constitutional rule that has to be measured up against future legislation that may be enacted by the representatives of the people. Those are some of the thoughts that may help you understand how we applied constitutional analysis in deciding that although the legislature, as the voice of the people, has ample power to enact this statute, that we didn't want to become the most dangerous branch of government by taking that decision into our hands and away from the people in a way that would have us doing all the fine regulation that ultimately is a job for the people in a self-governing democracy. Those are my thoughts on that. I look forward to joining in the panel discussion. Thank you all very much.